Mr. Martin, you recognize.
Well, Your Honor, if it pleases the court, first of all, let me say there was no execution involved here. And I had intended to say less than I am going to say because it seems that the Attorney General's office has shared this video with you and gave you a portion of the facts, and Mr. Sellers, who I respect, has given his client's side of the story. But let me say a little bit, first of all, about Charles Lemons and about what happened here. First of all, Charles is 57 years old. He's born and raised in Marlboro County. He's been in law enforcement for approximately 26 years, I believe it is. 36 in the United States military, including mostly the National Guard, for 22 years. He has no criminal history, as you might imagine. He's been elected sheriff and is in his second term there in Marlboro County. He lives in Marlboro County currently with his sister. He is not married. He doesn't have any children, but he's been a lifelong resident of Marlboro County other than when he was in the military or in Iraq for his service to the country. Charles has led a commendable and a good, solid life contributing. On this day here, Judge, let me say to give you some more of the facts which they have begun to introduce to you. First of all, Mr. Jarrell Johnson was arrested that day at the home of his father. The incident report that was provided to me by the Attorney General's office and the information I have makes it clear that he was arrested for the brutal baseball beating with a bat of his father as his father was getting ready to go to church. Beat down. When the neighbor came, that neighbor was threatened, fled back to his house. Mother called 911. This deputy over here went to the scene. There was issues there, but they arrested Mr. Johnson, brought him to the jail. He continued to be disorderly according to the incident report, so the deputy asked for some assistance when he got to the jail. Sheriff Lemon was on his way to church. He went by the jail. I think there were others there. But again, it certainly seems to be a situation in which Mr. Johnson, and I don't know exactly why he was doing the things he was doing, but he was out of control, disorderly, combative, not following instructions. And of course you've seen the video, and it's one of those things that you would need to watch multiple times to get every facet of what was there. But it's clear that we believe that the Sheriff Lemon and the other deputy involved were doing the best they could to get him into the cell without any violence, or without anybody getting hurt. The taser is a non-lethal weapon given, or device, if you want to call it that. I don't think it's a weapon, given to law enforcement in order to try to maintain control, and that was used here. And I think the sheriff even said, you know, so that the inmate would know, arrestee, tase him if he doesn't go into the cell. And as soon as they take the handcuffs off of him, he puts a spin move on and goes towards the officers, and he's tased again. And that's when he's tased. So let me just say that again, Charles certainly takes the position that he's not guilty of assault and battery of a high and aggravated nature or misconduct in office, and that there is more than one side to this story. Obviously I don't have any idea at this time about the mental illness of Mr. Johnson or exactly what was happening with him that day. But I will say that in a jail setting, somebody's got to be in control. And the question is that going to be law enforcement, or is it going to be people who have been arrested and brought there? This is not anything I think that anybody wanted to happen, and I know the family of this young man are if they look at this video, are rightfully concerned But there is the rest of the story that has to be considered. And we think that the actions of Mr. Sheriff Lemon were reasonable and necessary in the scheme of what happened. And I wanted to be sure that you heard our side of that story in as much as you heard the others. This young man was 6 foot, according to the incident report, 6'3", 250 pounds, and was as I have been told, a former NFL football player. He was a big, strong man. And so we would ask that the court certainly, in this case, set bail, a reasonable bail. I believe under the Constitution that he may well be entitled to a personal recognizance bail. But we'll be, obviously, that's within the court's discretion to look at all the facts and to decide. But he's not a risk to flee. He's not a danger to the community. He intends to be front and center just as soon as the state will bring this case to trial to defend himself. And so we would ask that you set a reasonable bail considering all the circumstances.